Welcome once again to Lehto's Law. Here's Steve Lehto.
Alan tipped me off to a case out of the state of Washington where the Supreme Court ruled on something very interesting, and it raises several more interesting questions. First of all is how do the courts of appeal and the Supreme Courts of states, how do they interpret a statute? And the second question is, why do they interpret a statute, right? So for instance, the question is a snowmobile a motor vehicle? You might go, why would that matter? Well, it turns out it does matter. So in the case of Washington versus Wolvelaire and Julia Tucker, the case revolves on that exact issue. And the reason is that Tucker was accused of stealing a snowmobile, was found guilty, and convicted of theft of a motor vehicle. On appeal, she argues she could not have committed that crime because a snowmobile is not a motor vehicle. So the question then becomes, is a snowmobile a motor vehicle? If so, she is guilty of a theft of a motor vehicle. But if a snowmobile is not a motor vehicle, then she's not. So the court points out that in a previous case, State versus Barnes, there was a 3-3-3 opinion, which I'm not sure how you get that, because normally you go, who wins and who loses, but apparently, I don't know, ties? They had held that a riding lawnmower is not a motor vehicle under that statute. And so if someone stole a riding lawnmower, can they be convicted of stealing a motor vehicle? Now, they say that although the statutory language when read in context and in accordance with our general rules of interpretation, it does exclude lawnmowers, it unambiguously includes snowmobiles. But we'll see how unambiguous this is, because it's quite a lengthy opinion, as you might see. The state accused Tucker and a co-defendant of stealing a snowmobile and charged her with theft of a motor vehicle. A jury found her guilty. After trial, she argued that she could not have committed the crime because a snowmobile is not a motor vehicle for purposes of the theft of a motor vehicle statute. Observing that a snowmobile has a motor is a vehicle and, unlike a lawnmower, must be licensed, the trial judge rejected Tucker's argument and sentenced her to 26 months. The Court of Appeals reversed, relying on a decision regarding the lawnmower, and said that the statute criminalizes only theft of a car or other automobile. Now, there's a whole bunch of debate about this, but we'll go through it. First of all, to determine whether a snowmobile is a motor vehicle, for purposes of the theft of a motor vehicle statute, we begin with that statute. So the first thing you always do is you look at the statute. The statute defines the crime as a person is guilty of theft of a motor vehicle if he or she commits theft of a motor vehicle. Yes, it's called a bootstrap argument. The statute does not define motor vehicle. So when there's a statute that doesn't have a definition, then you ask yourself, where do you find definitions that you look at? We therefore turn to the Washington Criminal Code's list of definitions. The legislature instructs us to use these definitions when interpreting a criminal statute unless a different meaning plainly is required. That list defines vehicle as a motor vehicle as defined in the vehicle and traffic laws, any aircraft or any vessel equipped for propulsion by mechanical means or by sail. So the Washington Criminal Code instructs us to proceed to the cross-referenced vehicle and traffic laws located elsewhere. Now, there's a funny footnote at this point, because this Supreme Court panel chides the three-justice lead opinion in a previous case because they instead used a dictionary instead of using the criminal code. And they point out that you do not use dictionaries when the code has its own definitions. And that's actually a common sovereign citizen problem. They ignore definitions in the code and they go, well, look what a dictionary says. Dictionary is not the law. And now the Washington Supreme Court says so. The vehicle and traffic laws define motor vehicle as a vehicle that is self-propelled or a vehicle that is propelled by electric power obtained from overhead trolley wires. Vehicle is further defined as a device capable of being moved upon a public highway and in, upon, or by which any person or property is or may be transported or drawn upon a public highway. So a motor vehicle is a self-propelled device that is capable of moving and transporting people or property on a public highway. So it's a description of the mechanics and a description of its function. Where, as here, the legislature has provided a definition, we do not create our own. The trial judge reasoned that a snowmobile is a motor vehicle in part because a snowmobile must be licensed, but that's not what the definition says. So this court says, although such a requirement may provide the courts with a useful test, we cannot simply create a new requirement out of thin air. So a snowmobile is a self-propelled device. We must determine whether a snowmobile is a self-propelled device that is capable of moving and transporting people or property on a public highway. The laws explicitly define snowmobile as, by the way, the snowmobile is defined elsewhere in the code, a self-propelled vehicle that is capable of traveling over snow or ice. So a snowmobile is obviously capable of transporting people or property. The only remaining question is whether that self-propelled device is capable of moving and transporting people or property on a public highway. Some self-propelled devices are unquestionably able to move and to transport people or property on a public highway, such as cars, trucks, vans, or motorcycles. Some clearly are not. Jet skis, for instance. For others, it's a closer call. So here we're talking about now a snowmobile. But any ambiguity as whether a snowmobile is capable of moving and transporting people or property on a public highway is dispelled by the Snowmobile Act. That act is located in the statute, the very title to which the definition of vehicle in the Washington Code cross-references us. The Snowmobile Act not only makes clear that a snowmobile is capable of moving and transporting people or property on a public highway, at least when the highway is covered with snow or ice, but also makes clear that it is legally permitted to do so. The Act specifically allows people to operate a snowmobile upon a public roadway or highway in the following circumstances. And it talks about when you're allowed to use a snowmobile on the road. If a snowmobile were not capable of moving or transporting people or property on a public highway, this statute would be meaningless. So courts are always supposed to look at statutes and say, what do they say? And if it has one absurd result and one common sense result, you go with the common sense result. So obviously, the snowmobile is a vehicle that can self-propel itself, it can transport people, and it can do that on the highway. In fact, it's legally allowed to do so. Therefore, it is a motor vehicle. Therefore, the woman who is accused of stealing it is in fact guilty of theft of a motor vehicle. So the conclusion, a snowmobile is a motor vehicle for purposes of our statutes. Accordingly, we reverse the Court of Appeals and affirm Tucker's conviction. So there you go. So I know it seems like a long way to get there, but this is the kind of thing that happens when they originally wrote the statute. They could have said motor vehicle includes and listed all the thing it includes. Problem is that things might get invented, new things come along. What about a Segway? You know, do you remember the time before Segways? Did you realize they still exist? What about UTVs as opposed to an ATV? You know, so there are all kinds of things. And so rather than leaving a list, because you run the risk of leaving something off and then that people say, hey, it's not on the list. They instead said, well, a motor vehicle is, you know, defined elsewhere. Go look at that definition. And that definition is quite broad. But I will tell you that this opinion, the state of Washington apparently has 9 justices on the Supreme Court. This opinion is a 5-4. 5-4. 5 said, yep, we agree with this. 4 said, snowmobile is not a motor vehicle. So that's how it often is. And I don't know. I can simply tell you that the 4 who disagreed with this said that they didn't think a motor vehicle definition encompassed a snowmobile. And what they're really getting at underneath all of this is, and this is not what they're supposed to be doing, but both sides do this. They look at what they perceive the intent of the law was. And most people think that motor vehicle theft is car theft, Grand Theft Auto, right? I don't know, do they have snowmobiles in Grand Theft Auto? And so then the question is, did they really intend for someone who stole a snowmobile to be punished the same way as somebody steals a car? And that's not how we do it, though. They did it the right way. They actually said, well, here's what the statute says. Statute says, go look at this. You go look at this. You go look at this, and boom, you're done. You don't pull up dictionaries. You don't look at the intent of the drafters. Those are things you would do if these other things hadn't been done. So there have been times, I've seen a situation before where there's 2 possible interpretations of a statute and no other guidance. And at that point, you might look to see what the drafters intended. You might. And also, where there's a common word that's not defined, likewise, you might look to a dictionary if there's no legal meaning and it's not defined in the statute and it's unclear what it means. You know, then you might go to a dictionary. But it's never the first choice. In fact, it's rarely done. And in fact, as I've said before, I see it so rarely in opinions where they cite to a dictionary. Here, they're actually poking fun at the other side because they did it, and they said they did it wrong. So there you go, State of Washington versus Tucker. As of right now, in the state of Washington, for the purposes of the motor vehicle theft statute, snowmobiles are motor vehicles. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. How was your camping trip, you ask? It was intense.